So right on the front page here, page 1, line 14 through 18, in addition to any other restrictions, shall for any protective order issued after July 1st. So that means there's no retroactive confiscation of anything?
No, it's prospective.
Prospective. And then it says on line 16, a person restrained under this section. I noticed that the line, it was stricken out the defendant. Can you explain to me the difference between a person restrained under this and a defendant? Does that eliminate the due process of
No.
being...
A defendant is a person who's charged with a crime. They could also be a restrained person where someone has filed a restraining order against them, or there is a provision that they are restrained from possessing firearms. So they could be one and the same, but they don't have to be. So the restrained person is the person that this statute is trying to address under protective orders. It's the person who is restrained, and it doesn't necessarily have to be a defendant. They don't have to have been charged with a crime. You can just seek a restraining order.
So if someone seeks a restraining order and gets a restraining order, then the person that's restrained will have to surrender physical possession of all firearms, just under presumption of guilt. Am I reading that correctly?
The protective order section, if we're talking about the civil portion of it, is that a person would apply for a restraining order. They fill out an affidavit, you'd be entitled to a hearing. Both sides would presumably present evidence, pro and con, as to whether or not the restraining order should be granted. If the restraining order is granted, then under this section, once that protective order is issued or renewed, that person who has been found to be restrained will have to turn in the firearms, yes.
So does this remove the discretion from the court system, make it mandatory, or will it give will entitle the judge to make discretionary decisions as they can now?
Well, once the court determines that in favor of someone seeking a restraining order or a protective order, the court shall issue the order that that person is restrained. It's mandatory once the court makes the decision after a hearing.
So once a person is not a defendant but is restrained, so once they say that, yes, we're going to issue a restraining order, then their discretion is removed from the court. The judge's discretion is removed.
Once the decision is made by the judge, if the judge finds sufficient evidence to grant the restraining order, the judge shall issue the order. It becomes mandatory once they make the determination after a hearing. Presumably where both parties present evidence and testimony, but that's...
So a plea of nolo. So if someone gives a plea of nolo, which usually is a bargaining chip for, trying to save money or, just trying to bargain to.
Yes.
They didn't do anything, but they want to bargain. They did something, they want to bargain. If they plead nolo contendere, is that an admission of guilt, and would they have to surrender their firearms?
Yes.
At that point.
A plea of nolo means you don't contest the facts. In Rhode Island, it is not a conviction, but it is equivalent to a guilty plea. It's an admission for sure. You could receive a filing, which means the case stays open for a year. It's not a conviction as long as you don't violate it. Then after that, you are banned for that year from possessing, receiving firearms. Once that year is up, you can apply. If you pled nolo and received a probationary period of 1 year, and did not violate that probationary period, it does not become a conviction, and after that 1 year, you can also apply. So on a nolo plea to a filing or probation, you will be banned for the 1 year, but thereafter you can apply to get it back.
While we're on this conversation about the military and
The police officers and military and ramifications. I'll just remind you, that's pre-existing law. We're not changing
well,
that.
yes, I understand that, but from what I understand, one of the star witnesses that were in promotion of this bill had one of the most horrific stories about abuse and a gun held to her head and firearms problems. From what I understand, her significant other was an FBI agent. Would this have any effect on an FBI agent, a federal?
Well,
I guess my question is that from what I understand, there was a law enforcement officer involved in some abuse, and we're not addressing that in this bill. So my question is. So would this prohibit?
With regard to an FBI agent, I'm sure that I believe that they're governed by the federal law as it relates to the firearms. This particular section of the law, page 3, lines 25 through 33, is the existing law. The prohibition against possessing a firearm due solely to the existence of a domestic violence restraining order issued under this section shall not apply with respect to sworn peace officers and active members of military service, including members of the reserve components, who are required by law or departmental policy to carry department firearms while on duty, or any person who is required by their employment to carry a firearm in the performance of their duties. It says any individual exempted pursuant to this exception may possess a firearm only during the course of their employment. So, and it's got to be stored at the place of employment. So this is existing law. The changes to this statute do not affect the existing law relative to that.
My question was, why weren't we addressing that? I guess if it was an issue that was brought up in committee, that was my question.
Well, I'm not sure with regard to the federal, because I think it's governed by federal law.
Okay.
But this statute would make exemptions for a law enforcement officer, and an FBI agent certainly is a law enforcement officer.
Thank you.
You're welcome.
All right, again, Representative Price, that is pre-existing law, and nothing about this vote today or this bill will change that.
Committee, I just wanted to reflect on it. Thank you.
Okay.